Djanogly, Mr. Louhgton, welcome. We're glad to have you with us as we look at family justice. And I want to start with the Family Justice Review itself to establish what you may have either decided or may want to speculate at this stage about the timetable for implementing proposals in the review. I mean, the interim report said that the system is not working. The President of the Family Division says the courts are at breaking point now. So obviously there are things you might want to do quickly and things which will take longer. Yeah. Where are we on that?
Well, I think it's important firstly to say, Sir Alan, that a lot of work has been carried out by the government over the last year, and I'd be delighted to go into that in more detail, and perhaps it's important we should. But in terms of the review and the important proposals that it's going to take forward to bring together the various streams of work, not only that we have been carrying out, but also that the review's been looking at in other countries and across the board in this country. The timetable is that, the consultation document went out in March. The consultation will go on for a 3-month period. The final report is due in the autumn. The government will look to respond to that as quickly as possible. And our response will include an impact assessment, and that will then lead to us putting forward our implementation proposals before the end of this year.
And is there anything that you feel you could be doing at this stage, which is in Norgrove, without waiting for the next stage of consultation?
Well, the answer is yes. Some people have said, why don't you wait until Norgrove has responded, until you do anything? And given the state of the system as it exists and the urgent needs of children waiting for court cases, we felt that we had to act. So I can tell you, for instance, that last year we approved 4,000 extra county court hearing days, and I have just approved another 4,000 this year. We feel that immediate investment in the system in that regard is necessary to deal with the delays that are there at the moment. It goes much more deeper than that, not only in terms of an immediate reaction, in terms of the view that MOJ and indeed DFE have as to how we should be working together. One of the immediate problems that we saw when we came into government was the lack of joined-up thinking between departments and indeed with the judiciary. And we have immediately acted to rectify that. We now hold, at the highest level, we now hold quarterly meetings between myself, Mr. Louhgton, and Sir Nicholas Wall, President of the Family Division. Those have proved to be very helpful and hopefully providing a degree of leadership at the highest level that didn't exist previously. At the lower level, we've instituted a series of local performance improvements groups. There are now, these started in October of last year, I think the first one started. There are now some 40, I think over 42 of them around the country. These are multidisciplinary, bringing together local authority representatives, local judges, HMCS, CAFCAS, and LSC, and sometimes local lawyers are invited along as well. And working together, they are already providing excellent results in terms of identifying problem areas relevant to that area. You specifically mentioned at the start, Sir Alan, that the system's not working and the system's at breaking point. Quotes, you attributed those to various people. What I would say is that actually it's rather more complicated than that. When you look at it on the ground, some areas are doing much better than others. In particular, some CAFCASs are performing better than others, and some courts are performing better than others. In the courts field, I can tell you that average case in public law may be 53 weeks, case lengths may be 53 weeks. But actually in the best performing courts, they're turning around cases in under 30 weeks. So the question is firstly looking and identifying what's going on in specific areas, and we now have the means to do that, and then pulling those together and looking at it nationally, and we can do that through the new National Performance Partnership which we set up at the higher end to look at best practice across the country. So a lot is already going on, and obviously, we're looking forward to the Family Justice Review pulling that together.
The review panel were unable to cost their proposals because of what they described as an absence of information about the costs of the current system. So how can you make decisions about implementation when you don't know what the proposals will cost?
Well, I think it's important to make the preliminary point here that we will wait until the final review, until we look at the cost implications in government. The review team itself has identified a whole series of gaps in the statistics that they need to find out before they can put costs. So the costs that appear in the initial report are actually very high level. But if you do look at the report, page 25, paragraph 133, they say it quite succinctly. They say it is not possible to cost our proposals in the absence of information about the cost of the current system, but we believe that by removing duplication, refocusing the court's attention, and encouraging other methods of dispute resolution, costs will be reduced. And then they say we will continue to work on this. And clearly, Sir Alan, MOJ and DFE will do our best to help them in identifying those costs so that we can benefit from that information at the time of the final report.
Can I chip in perhaps, because I think clearly there are going to be structural changes that will be required if we're to move ahead with the Norgrave report that will have some costs attached to them. A lot of the solutions that we can bring to bear sooner rather than later are to do with communication and better management. And I think the points that Sir Nicholas Wall and the senior judges you had in front of you said that actually a lot more could be done with the existing funding that is there, recognising there's not going to be, on the face of it, a lot of extra funding coming in. And the duplication that the report refers to is a major source of cost. And I think the bureaucracy around a lot of the proceedings and the lack of trust between various different agencies involved in the court procedures, such that the duplication of expert reports and everything else is bringing about costs now which needn't be there. And actually, if everybody spoke to each other rather better, we had a rather better handle on the management, which is what we're trying to bring about now, ahead of the structural changes, then I think we could speed things up and save a bit of money in the process.
But one of the areas of greatest cost uncertainty is integrated IT, which the panel saw as a very important part of the integration of the whole system. Don't you face that with some apprehension?
The answer is yes. I agree. The answer is yes. The report quite rightly points out that different parts of the system are operating off different statistics, and in terms of court days and what that means from a CAFCAS point of view might not mean the same from an MOJ point of view. I mean, one of the advantages of this report, the final report, I think, will be to identify those areas where people are working off different bases and pull them together, and that would.
But that's not quite the same thing as having an integrated IT system, which is a notoriously difficult thing to achieve.
I think part of the problem is they haven't got a centralised integrated information system at all, let alone a technical solution to this. So having the headquarters brought together in Coventry is a start to that. Now, it may well turn out that there will have to be a serious project for centralising IT to go with it. The history of central government-initiated IT projects is not one of that makes one sort of jump up and down with joy, of course, Simon, in this. So we need to look at that very, very carefully. But it does strike us, I think, that the admin procedures of CAFCAS are slightly behind time, and we need to get up to speed with it. So IT is going to be part of that solution, I'm sure.
Of course, the positive side of this, Sir Alan, is that having various IT systems where hopefully at the end of the day one will be in place could actually be a cost saver as well.
How often have I heard that?
Yes.
Well, indeed. But this time we'll get it right, I'm sure.
Yasmin Qureshi.
Minister, I want to ask you some questions about the proposed Family Justice Service. Firstly, what's your understanding of how this would work? because as you know, there have been a number of recommendations made by the Family Justice Review about this, and in particular about the question of ensuring that there is the independence of the judiciary and the full role for the President of the Family Division in this whole setup.
Well, I think your question, is a very broad one and goes to the heart of really about the sort of system that we want to see set up at the end of this. And I think the starting point is the statutory framework. The terms of reference for the review was that we should work within the existing statutory framework, but the review team could look to question that. And I was very pleased to see that they have fundamentally accepted the existing statutory framework. They say it is fit for purpose, and they have said that they have reinforced the principle that the interest of the child should remain paramount, and also reinforced the idea that the voice of the child should be heard more prominently within the system. And I think that is a very good starting point. Equally, I think that they also make the strong point that where people reach agreement within the system, either privately, through contract perhaps, or through court order, there should be greater adherence to what has been agreed. And I think that has also come strongly through their report, and is something that I would certainly endorse as well. The Family Justice Service should bring support for the needs of children and families to work together more coherently. And I think the key towards changing the system to address that will be to have more and closer joint working between the various agencies, to take out the high levels of duplication that exists within the system, to increase efficiency within the system, to reduce the delay and the financial and emotional costs that exist for children and families within the system at the moment.
Can I also ask, in relation to the fact that the government has itself estimated that the proposed changes to legal aid, about 211,000 people will no longer receive legal help, and about 53,500 people will no longer receive representation for private law cases, and is budgeted for extra mediations. How are we going to do? Is the government going to deal with the fact that it's accepted generally that in areas of family law, people will not just give up because they don't have public funding, and they're going to carry on trying to argue their cases? And what plannings or what have the government got to deal with these types of scenarios?
Well, firstly, it's not the government's intention by any means that people give up. And I think it's very important to make the opening point here that 90% of separating couples reach agreements between themselves or with varying degrees of mediation. And that what we're actually talking about is the very small minority, about a tenth of the cases, where at the moment they, for one reason or another, they don't reach agreement between themselves, and they want to take their case to court. And the government is saying here that in such a situation, we believe that more of those people, not all of them, some of them will have to go to court. There may be terrible incidents of violence or whatever, where court is going to be the option. But to a great extent, we believe that a lot of those cases should have an alternative, a non-court alternative. By providing a non-court alternative, yes, we can take cases out of the system, which will help to declog a clogged system. Yes, we can get savings to the taxpayer. And yes, we also believe that for the majority, there will be a better outcome through alternative procedures such as conciliation or mediation, where the evidence suggests that the costs are cheaper, literally a fifth of going to court, and the time taken to take the case through is much quicker as well.
Okay. And would you therefore also allow a provision or have a provision in it that a judge who feels that this case needs, say, a legal representation, is able to make that decision?
Well, I mean, the decision as to whether someone has legal representation is ultimately their own. I think the question is whether they can afford to pay for that legal representation. And in a situation where there is domestic violence, of course, where it is a public family law matter, where there is an instance of a threat to the child, in those situations then legal aid will be available.
Mr. Evans.
Yes, I'm concerned. I've read through the pre-action protocol for mediation. I'm concerned by the costs. Is it realistic to budget for a 3,300 increase in mediations when more than 200,000 litigants will no longer be eligible for legal aid?
Well, I'm firstly very pleased that you brought up the pre-action protocol, which came into effect on the 6th of this month, and is something that I'm very pleased with. That was a significant piece of work for the department. Of course, to directly answer your question, it's important to realise that at the moment, if someone is eligible for legal aid, they will be eligible, that they have to go to mediation assessment. So what we're proposing is not a new system if you're within the publicly funded sector. What we're doing is extending that system to the privately funded sector, if you like. We have no maximum number of mediations that we will permit. I mean, you mentioned a figure, that comes from the impact assessment. If it is more, we would be pleased, because that would be less court costs. The more mediation, the better, as far as we are concerned, and we will fund it. If someone is currently eligible for legal aid, they will be eligible if our proposals come into effect for mediation.
What's concerning me is that it says here, brief initial analysis estimate that 3,300 more mediations might be provided at an additional cost of £5 million.
Yes,
and that's what I'm concerned about. Are we talking about costs maybe running away with themselves here?
No, I don't. We don't believe so. I think we can come back to you on that, but I think the variation, because of course all of these are averages, and I think the variation is 5 to 7 million. But at 7 million, that would still be fine within our savings projections, and indeed it's the right thing to do, because this government supports mediation and supports it as a form of early intervention. It's better to get to the cases early and deal with the problems, not least in terms of the interest of the families and the children involved, early non-conflict resolution, rather than long drawn-out court cases.
Just to stick, last question really on costs. How can you ensure the protocol does not add costs and delays because one party is not cooperating and just being completely unreasonable? How can we make sure that the costs can stay down in that way?
Well, ultimately, our proposals for mediation are non-compulsory mediation. So, of course, even if someone goes for a mediation assessment, if they want to be difficult, they can say, I'm not interested in mediation. If that is the case, then the case goes immediately to court. That is reason for the assessment coming to an end, if you will. So I don't see this as being a cause of delay. I only see this as a cause of cases being speeded up.
What are your views on compulsory mediation outside of, obviously, you've got the...
Well, the government's view to date, obviously in the pre-action protocol that's been adopted, is that that is not the way to go forward. But we're not closed. We're not closed to. We don't have closed minds on this issue. Interestingly, the views of the Family Justice Review in their interim report are also not to go for compulsory mediation, although I know they looked at it in Australia. They are taking our position slightly forward, though. I mean, it's important to note that they have accepted the government's position and support it. But they are saying we should go slightly forward by saying that it should be open for judges if there was a situation where one party was being difficult, for instance, and didn't want to engage in the mediation. The interim review is actually saying that in such a situation, the judge could take that into consideration in looking at the cost situation. And that is something the government will certainly be keen to look at. I know they're going to be doing more, the review team's going to be doing more work on that aspect up to the final report, and we'll look at that with interest.
And an AO report says that the average mediation cost £753 and took 110 days. Cases that went to court cost £1,682 and took 435 days. Is there an aspiration to reduce the amount of time a mediation takes from the government's point of view? Is there any sort of targets there to reduce those even further, those costs?
Well, I mean, mediations are not conducted through the government, obviously, but to be frank, our concentration is going to be on reducing court times rather than mediation times.
And the last question I've got there, the NSPCC, and my colleague touched on this, among others, expressed concern the voice of the child is not heard in mediation. How can you ensure mediation produces results that are in the best interest of the child rather than the parents?
Sorry, the door was slamming. I couldn't hear.
My colleague touched on it, about the voice of the child. How
Yes.
can you make sure the voice of the child is heard during the mediation process and it's in the best interest of the child, not just the parents?
The current guidelines that mediators follow have very specific proposals for how a child should be dealt with within a mediation. And they very much highlight the importance of the child. And indeed, within a mediation, the mediator will engage the child in the mediation. And I would go so far as to say, from everything that I've seen, a child is more likely to be given a fair hearing in a less formal atmosphere, which for a child can obviously be very important, through mediation than is the case through a court process. So I actually think that in most cases, obviously there are exceptions, and if there's violence involved or so forth, that might not be the case, and court might be the way to go. But in a normal situation, I would say that the voice of the child would be heard in just as fair a fashion through mediation, if not more so, through mediation rather than going through court.
And the other thing as well, we've heard from a number of evidence that mediation is patchy. How can you ensure, the department ensure that there's high quality mediation available to everybody?
Yeah. Well, if someone is having mediation which is being paid for by the taxpayer, LSC-funded mediation, if they're eligible for legal aid, then they would have to go to a mediator approved by the LSC, which basically means Family Mediation Council qualifying levels apply. They have the FMC have worked very hard on this. They now have a kite mark, and that provides a pretty high level of mediation. If someone privately wants to go to mediation, of course they don't. We are now saying that they have to go for assessment before they issue court proceedings. But they may not want to go through the court system at all, or the public system. They may want to use their neighbour as a mediator. This sort of thing happens in real life. What we are saying, though, is that there should be higher levels for those who do go to mediators. There should be an expectation of a certain quality. So we are working on that at the moment with the FMC.
Is that just the Justice Department, or are both departments involved in the mediation issue?
Sure.
That is Justice Department, because it's the Justice Department's form that has to be handed in to the court in order that they can show that they have been assessed for mediation.
You can't be entirely unconcerned about the quality of mediation available to those who are not getting legal aid, can you?
No, I am indeed concerned, and a lot of work is going on between the MOJ and the FMC in terms of getting a set level between mediators. I mean, this is going to take time, but it's something that's very much being concentrated on. And I know also that the professional bodies, such as the Law Society, are very keen that this should happen as well. So I think we're all heading in the same direction.
Elizabeth Tress.
Thank you, Sir Alan. Mr. Louhgton, in terms of the Public Accounts Committee's report on the performance of CAFCAS, My understanding is the government's recommendation was that, despite agreeing with the recommendations in the report, that you supported the continuation of CAFCAS as an organisation. Could you perhaps outline the other alternatives the government considered and why you decided to maintain CAFCAS in its current organisational structure?
Well, that was the PAC report from last November, which didn't come out in the most glowing terms for CAFCAS, was at a time when the Norgrove Review was obviously starting its work and hadn't reported. So we declined to make any views on the future of CAFCAS until after Norgrove. Now, Norgrove, in the interim report, quite clearly stated that the future of CAFCAS should be within the new Family Justice Service and transfer responsibility to MOJ. Now, there were some people in the past who said, well, we should scrap CAFCAS altogether. Mm-hmm. But you have to have somebody doing that job. And I think also we took the view that with all the problems there are with CAFCAS, we are going through some quite, hopefully, abnormal times at the moment, given the very high increase in workload that CAFCAS has been faced with post-Baby Peter from 2008 onwards. And there are a number of reforms going through with CAFCAS, a number of improvements which are beginning to bear fruit, and there have been some signs of improvement. And on that basis, we deferred any decision about the actual future structure of CAFCAS until after Norgrove. I think it was slightly unfair to judge CAFCAS at that precise time, and I think the verdict, the rather easily banded around soundbite about CAFCAS at the time was slightly unfair, given the extraordinary demands upon that service.
So do you support the idea that the service will move to the MOJ from the Department for Education?
Well, we're not going to make a final judgment until we've got the final report, but we've had meetings with David Norgrove and his review team, including my Secretary of State and the Lord Chancellor and the ministers directly involved. And I think we all see a deal of logic in that direction. There's a lot of work to be done on the detail of a transition, the status of CAFCAS within a court service within the MOJ, how we retain the integrity of CAFCAS, the integrity of a board of CAFCAS. But CAFCAS is a very different animal to the court service, where there's a lot of administrative people there. CAFCAS employs an awful lot of social workers with different skill sets as well. So, in principle, I think that direction probably has met favourable response from both departments. But then you have to start thrashing out the detail, and that's a rather more complicated process.
Are other alternatives to CAFCAS being considered, rather than just looking at, is the current system working? Are we looking at what would work what works in other systems? How is this handled elsewhere? Has there been a more open study by the government into this, aside from the Norgrove Review? Is that something you're actively looking at?
Well, we're not looking at a CAFCAS Mark II, but the problems with CAFCAS are not just about CAFCAS. The problems relate to the whole of the way we run family courts in terms of protection, private law and everything else that goes with it. Now, there are a number of reviews running at the moment that are very germane to what happens with CAFCAS, starting with the Munro Review. The Munro Review is going to come out next month with some quite radical proposals that will have big implications for the way family courts look after public law cases, particularly around safeguarding. Mm-hmm. And CAFCAS will need to be able to respond to that if that's to be successful. The judiciary will need to have to respond to that. Local authorities and social workers absolutely will need to have to change their ways if we are to improve the whole system. And if we get all of that right, then the implications are that CAFCAS, in whatever form it is, under which other umbrella it is in the future, will be able to do its job more effectively and swifter and better focused on the child, which is absolutely germane to all of this.
To what extent do you think the current problems in CAFCAS are the quality of the management as opposed to the organisational structure the way it works?
Well, I think it's a combination of both and other things, which is why I think it's really difficult just to put your finger on this is what has gone wrong in Kafka's, and to try and put all the problems happening in the family justice system at the moment on Kafka's, as I say, I think is unfair. I think it's a combination of things. I think it's the quality of social work and the demands on social workers involved in safeguarding at the moment. High caseloads, high turnover, low morale, high vacancy rates, and a very, very bureaucratic system such that they're spending 80% of their time, as Unison will claim, in front of a computer screen rather than eyeballing the people they're there to protect. Secondly, it's Kafka's itself and the workers they've got, the vacancy rates that they've had. I think the whole way it was managed right from the start, when it was set up under the aegis of the now chairman of the PAC committee, interestingly, when she was the first children's minister. And then I think the judiciary itself, too, is not the most efficient way of running some of these cases. And again, Norgrave has some very interesting things to say there, comparing it with the way they run it in other countries. But in all of this, it is, as Jonathan has said, it is a very mixed picture. And I can take you to some Kafka's offices that are running very efficiently. And then I can take you another one, which I shall be visiting shortly, which this isn't. Now, why is it within the same organisation can they get things quite right in one part of the country and quite wrong in another part? And I think there's poor dissemination of best practice, and to an extent that is down to management. Management at the top, but also management at the regional level and the local level. But then you could say, well, that's actually ultimately the responsibility of the national management to get it right. And I think we've all been frustrated with the time it's taken for some of the poorer performing areas to improve. And again, part of this, is it down to communication? Are they actually talking to those areas which are doing it better now? And if they're not, why not? And why haven't management done something about it?
What would you say the crucial factor is between the areas that are doing well and the ones that are doing badly?
Communication. But the one thing I found absolutely extraordinary, and I've sat in on a number of family courts, I visit Kafka's, most weeks I'm visiting a children's services department and talking to social workers. And let's take the example of adoption, which is quite a contentious issue at the moment. And I've sat in on adoption panels where they will claim that all the problems are actually down to all the delays caused in the courts, for ever asking for yet more expert witness reports and delays. They go and speak to the judges and they say, oh, all the problems are down to the adoption panels. They're always taking forever to meet and decide. So I said, well, have you spoken to each other? Well, that doesn't happen, apparently. So I had to write to every local authority in the country saying, would your adoption panel people please go and have a chat with the judges? And Sir Nicholas Hall has made the same recommendation to his people as well. And Kafka should be in that loop. Local authority social workers should be in that loop. And it hasn't happened. And that just seems absurd that people are not talking to each other to try and get the system working more efficiently, which is why these local performance improvement groups are absolutely essential. 42 we've already got up and running, to making sure that people are communicating with each other to see where the problems are and what they're doing about them.
There was an obsession with targets and statistics, and actually what was missing was communication.
But it's often when you've got a series of centralised organisations that report upwards, they don't necessarily communicate on a horizontal level with each other. I mean, that can be a structural problem.
But what is interesting is that when actually real people get round a table locally, they appear to be doing some good things. So just bunging a whole load of top-down targets and directives on them isn't necessarily the way to do it. The way to do it is to make sure that we learn how they're doing it well there, and say, why are you not doing it often next door in some cases?
Can
I just, following on from what was just said, can I just put this question to you both? A typical scenario in the family court nowadays is appearing before a family court judge, and one of the former partners will allege violence and or sexual interference with a child. That, unfortunately, is very often used as a ploy in order to spin the matter out. Not always, but very often. Judges, with the best will in the world, want a finding of fact hearing within a reasonable time, and they're unable to do so. that immediately puts in a huge delay in the system, which then impacts on judicial performance, on Kafkas and everybody else. What can we do to sort this out?
Well, you're talking here public or private?
It could be either, but public principally.
Public, okay. Well, generally there is a recognition within those of us who are involved, and this came out in the Family Justice Review as well, that too many people are not taking enough notice of what courts are saying, and we do need a tougher approach towards enforcement of what has been agreed.
But is it not, gentlemen, a resource issue? Because, as I say, family judges are people who are committed to the work they do, and they want things done properly for the children. And when they see their diary coming up from below them saying they haven't got a free day for 4 months, it's not good stuff at all, really.
Well, I mean, I'll refer you to the Family Justice Review interim report, paragraph 17. They say more money would not be the answer, even if it were available. Major reform is needed to ensure better outcomes and make better use of the available resources. And I mean, that runs through the report in many different ways. It's not fundamentally a resourcing issue. There is huge duplication within the system as it exists, between our departments, between the various services, with significant cost implications. We need to sort those out.
I think, can I add to that? 'Cause there's, on several levels, there's a lack of management. Who actually is running the courts? There's a lack of joined up ownership of this, and which is why the suggestion of a chief executive of the Family Justice Service coming in to get a handle on all of this. Who is in control? Is it the social worker? Is it Kafkas? Is it the judge? It should be the judge. I think one of the things that the Norgrove Review highlights. It's finding 64. Judges have a natural tendency to look for certainty and support in making difficult emotionally demanding judgments. This has been exacerbated by lack of trust in the judgment of local authority social workers, and it's not just them, it's others as well, which leads, I think, judges to ask for excessive amounts of documentation, expert reports, which takes time, causes delay, and causes cost as well. Now, if we get people talking together, we get a system that works together, we might have a system that actually, where the major players trust each other. This is absolutely where Eileen Munro is coming from in terms of the social worker input into all of this. You know, there are people, I think, who should be available to give evidence in court, who are rarely called upon, such as foster carers, for example. You know, I go and speak to foster carers, and rarely do they get asked into court to give their view on the future of a child who they may have been looking after for months or even years, and yet they probably have got a better formed view than a Kafkas guardian who spent half an hour with the child in the last 3 months, but they're not asked, for example. So I think better communication and better trust. On even your specific point around violence as well, I spent a week being a social worker effectively last October up in Stockport, which was a really useful use of my time and absolutely fascinating in seeing it really from the sharp end. One thing I hadn't completely appreciated was just how much of children's safeguarding cases, which then end up in court, are related to domestic violence.
Related to?
Domestic violence.
Domestic violence.
And it may then turn out to have the sort of claims and counterclaims which you mentioned. And I think this is a problem that we underplay. In the team I worked with in Stockport, there was a specialist domestic violence social worker on the safeguarding team. She was an absolute linchpin, a really good social worker as well, a real linchpin of that team, whose expertise on determining domestic violence angles to various cases and the expertise she brought to bear on it were absolutely invaluable. And I think that's an example we could do more of in integrating domestic violence teams, of which there's some good expertise around the country, but often in a silo from what safeguarding units are doing, and the two are very closely bound up.
Thank you. Can I move on to Kafkas itself? In a previous evidence session before us, Mrs Justice Pawley said, and I quote, that there was a major anxiety that the self-employed guardians, generally the more mature and more experienced guardians, are viewed by some areas as being too expensive. And she says, in the judge's experience, those are precisely the individuals who are best able to help in private and public law cases. Kafka's figures, in fact, show that self-employed staff are not only cheaper than agency staff, they're marginally cheaper than directly employed staff. They also offer flexibility, and as we've already heard, they're popular with the judiciary. Given this, why does Kafka's seem to be making less use of them now?
Well, I think one, that's largely an operational matter for Kafka's, but I agree with the comments of the judge that there is a great deal of expertise in that those self-employed workers. There used to be many more of them working within Kafka's before the reorganisation, obviously back in 2003, who did a really rather good job. And part of the problems with Kafka's now are, I'm afraid, the hemorrhaging of some of those staff going back 10 years.
I have to say that when we did our report on Kafka's a long time ago, which led to the resignation of the board, we were warned by the self-employed guardians that this is what would happen.
Well, and they were right, and you were right to highlight that at the time. Indeed, it was one of the concerns. I'd just become Shadow Children's Minister in those days. One of the concerns that many of us raised as well, that we seem to be losing a huge amount of expertise and grey hairs, to put it in that respect. Now, that's double-sided, because part of the problem with Kafka's now is the age demographics of the workforce is such that an awful lot are coming up to retirement. Many of them have chosen to take early retirement, as have many social workers already, in any case, which means we are losing a lot of that expertise. I mean, something over half, I think, of Kafka's workers are over the age of 50, which is quite alarming. And if we don't get Kafka's right in whatever form, then I fear that many more of them will decide to vote with their feet and leave as well at a time we can ill afford that. So we need to use all the expertise that there is. I mean, there's been a problem with Kafka's in their sickness rates, yes, which they've started to get on top of, and is now down to about the average for equivalent public sector workers. But again, it's highly differential in different parts of the country.
Thank you. With regard to the spike in cases brought to court after the baby Peter case, it is argued that some were chronic neglect cases, and that really there were strong arguments that these should have been brought to court sooner anyway. Do you accept that the number of public law cases may well continue at the current level for some time to come? And are you planning on that basis?
The answer to that is I fear they will, and the figures for March, 882 care applications, was the highest monthly figure on record. Now, there's been an increase of, I think, 35% of care and supervision cases over the last couple of years post-baby Peter. That's a huge increase for any organisation to deal with, let alone one that was in a relatively fragile state as Kafka's was at that stage. So whatever's happened with Kafka's, I think we've got to look at it in the context of the huge additional workload. Now, why did that happen?
Can I just interrupt you briefly? I mean, this is one of the reasons why we took the immediate decision to increase the number of county court family days, and indeed that has not only that will not only cover the increase of cases, but also reduce the backlog.
The 2 points I was going to make was one, has that spike happened because the people responsible are doing their job better, and that actually they should have been seeking out some of these cases rather more efficiently pre-baby Peter, and so this is a reaction to that? Or are they being too risk-averse? So that could be another baby Pete, quick, we better start care proceedings, whereas in the past they may have given that family the benefit of the doubt, and they may have put more resources into keeping that family together rather than taking the child into care on a temporary or full-time basis. I think that's a difficult call, but certainly the number of children in care whom the courts have then upheld that that's the right decision would suggest that perhaps more children should have come into the care system pre-baby Peter than actually did, which is part of the problem. Now, the delay point, because it's now taking on average 53 weeks, there is a delayed effect, and we will still see the effect of the post-baby Peter spike for some while to come, I fear, because of the time it's taking to get them through the court. So even though the numbers of coming up now, I think, are falling off, the numbers going through the courts will actually continue to be quite high, although I think last month the number of disposals actually showed a slight increase, which was an encouraging chink of light at the end of the tunnel, but we've got a way to go yet.
Thank you. Baroness Howarth told us that while Kafkas had cleared the backlogs, and I quote, "I'm sure that it's true, in effect, that children don't see enough of their social workers." Do you think this is acceptable, and how can Kafkas ensure that the courts are fully appraised of a child's best interests and wishes whilst providing a safe minimum service?
It's not acceptable, and that view and figures related to it have come up in numerous reports, not least the Children's Rights Director with his regular and very good surveys of children in the care system, who will say that they don't see enough of their social worker, or they don't see the same social worker because of the high turnover in social workers. And I set up a group of children in the care system who come and see me on a quarterly basis now. I know a group of young people who've been through the care system as well, who come and tell me what the situation really is at the sharp end, and they don't hold back. And a common complaint, absolutely, is the lack of quality interaction, despite the best endeavours of social workers, because of chasing hotels with high caseloads and everything else, is not there. And that's a false economy as well. Now, again, the Monroe report is very much focused on the wishes and feelings and the journey of the child. And what she's trying to do is to ask the fundamental question, well, if the system were to change, how would it need to change to make sure that the child is getting a much better deal and everything is focused on getting the best deal for that child and the child being part of that deal as well, which means entirely taking on board, where they're old enough, their wishes and feelings and their welfare. And the point I made earlier about, again, despite the best intentions and some very good people working within Kafkas as guardians and others, the amount of quality time that they do spend or are able to spend with the actual children in many cases is far too low, and yet the judges will place great store on the views of that guardian, and yet there may be other people involved in those court processes who have spent rather more quality time with the child, who don't get as much as a look in for their views, which may be rather better informed. And that seems to me an odd way of doing it.
Thank you.
Mr. Gunn.
If I may just ask one supplementary on Kafkas, Mr. Louhgton. In simple terms, are you not just describing the deficiencies of Kafkas, variable quality across the country, as the deficiencies of any monopoly?
Well, that's a rather interesting and much bigger question. Should there be some competition within the safeguarding and the care of children scenario? That's probably an argument for another day. What are the incentives on Kafkas to get it right? Well, the fact that they are facing big shake-ups and greater transparency in how they're getting it wrong, that they can't sustain. And it will mean, big implications for who's running Kafkas and how it's run if we don't see sustainable signs that it is going right. So I think the antidote at this stage to a monopoly is the sunlight and transparency of better scrutiny and accessibility to actually what is going on there. And part of the problem is all the different agencies, Kafkas and others, use different sets of figures and assessments, as well as costs, which is why it's so difficult to get a handle on all of this and find out exactly where the problem is, hence needing to have proper management of the whole system, which is what Norgrove is trying to work towards. And Kafkas is a part of that, but it's not the only problematic part of that.
Thank you. Could I just pick up on one thing you were talking about, case management? It's a common complaint, which I'm sure you have heard many more times than I, about the number of adjournments. It's running 80% at the moment in my family courts in Ipswich. And the inability of the judges there to be able to manage cases efficiently, to not to employ wasted cost orders when they should do, people getting off with delaying the court process time after time after time, repeat offenders, be they particular social workers, Kafkas, lawyers, whatever. And no one ever bears the cost of that. And you rightly say there should be more communication, which is the good side of it. But what happens when things go wrong? And if I can ask the further question to that, who will actually make sure the judges are managing their cases properly and bear the consequences of poor case management?
Okay, this is a very important question, and one that is addressed quite significantly by the Family Justice Review team. They have looked at how other countries work, and they have come up, the Norgrove team have come up with management practices from other countries that show that there's much more transparency in other countries as to how judges operate and how they allocate their time and so forth. The Justice Review team is going to be doing more work on that aspect. I can assure you it is an area that the government takes a great amount of interest in for all the reasons you've just given, and we will be looking to see action in this regard following the final report. That has to be balanced with the point made by Sir Nicholas Wall in his response to the Family Justice Review that the independence of the judiciary must be sustained. There's clearly a balance to be had here, but I do agree with you that we will want to see better management systems put in place so that we do get better value for money in the way that we use our courts.
And continuity and consistency as well. It seems absurd to me that in too many cases will be different judges seeing a court a case through.
Yeah.
Not least in this, probably one of the most sensitive areas of family law, where you're dealing with deeply damaged children and families. You desperately need the continuity of the same social worker and guardian and other dealing with them, which too often isn't there. And when you've got a different judge piloting the various stages of the case through, and then it gets delayed because as a criminal case comes in that the judge is involved, etc., etc. It seems to be a remarkably inefficient way of doing it. And you said, well, who bears the cost of all this? The child bears the cost of all this, and that's why the delay is absolutely unacceptable. But there are ways of doing it better. If you go and visit, I don't know if you've had him in front of you, but certainly he's given evidence to past select committees, Nick Crichton and his Family Drug and Alcohol Court in Wells Street, which I've sat in many times, and he is part of the Munro Review panel, and I think is a remarkably talented and inspirational judge, who basically, his productivity levels are enormous because he sits there and ploughs through the cases. He'll have a mother in every Monday morning, if that's what it takes to make sure that she is following the guidance of the court. He will sit till late on Christmas Eve, if that's what it takes to make sure that cases aren't just left in limbo and adjourned for another few months or whatever. And he makes time to see those cases through. And I think most people who've been through his court will agree that they've had a sympathetic and efficient hearing. Whether or not they like the outcome is another matter, but they are seen very much as an individual case rather than as a statistic. And the Family Drug and Alcohol Court pilots, which he has been running, again, I think this came up in the earlier statements from Sir Nicholas Wall and others, are doing some very incredibly interesting things about how you deal with deeply, deeply damaged relationships between children on the cusp of going to care and their parents. And it's a much more efficient way of running things. Certainly, it may cost some more money up front, but the amount of money it's saving, because they don't then have children coming to care in most cases, or you haven't got the case dragging on for years and years and years at high cost. I think we've got a lot to learn from that pilot.
Could I just add, Sir Alan, that in fairness to the judiciary, this is not an issue that they have ignored. They have been working on it, and I should point out that only 2 weeks ago, the President's guidance on listing and hearing came out, which addresses this exact point. They're looking to reduce delay through the system, but also continuity of judges running through cases. Now that particular point is also featured very clearly in the Family Justice Review, and so let's see now how the Justice Review team take on board what the judiciary have just come out with. I would be very interested to see that. But it would be wrong to say that this is a point that has not gone noticed by the judiciary.
Sure. May I ask 3 very quick questions about expert witnesses? Mr. Djanogly, you mentioned in the previous session about your consideration of Rule 9.5 cases where the child will continue to receive legal aid for expert witnesses. What happens when the parents might require, or the judge will direct the parents require expert witnesses for their side, but they are unable to afford it? Are you looking at that?
Well, under the proposals, experts would be available not only in exceptional circumstances, but also, we're talking about private family law cases here, where there's domestic violence and where a child is separately represented, as well as in all public law cases. If violence is there, then legal aid will be provided.
On the issue of the fee cut...
Just before we leave that, what if it's the judge who forms the view that there's something about this case other than the factors you've described, which makes it perhaps unusually necessary to have some piece of expert evidence? It's not clear who would then pay for it.
Well, I think it's the LSC who makes the decision now, not the judge. However, what we're looking at very carefully as part of our legal aid review, which will be we will be responding to shortly, and we are very carefully looking at this question of what constitutes domestic violence, and in that regard, we are looking at different measures as to when that will apply, and certainly the views of the judge in a case are obviously being looked at in that context. So I think the answer to Mr. Gunner's question is that we are looking at that carefully.
But to follow Mr. Allen's point, I always thought that the judge had an inherent right to override the system in the interest of justice and to say, here is a case deserving of public representation.
I think in that situation the case would probably be adjourned and the judge's views would be made clear to the LSC. But if you would like, I can come back with the procedure on that in more detail. Would you like that? With pleasure.
Go, Mr. Gunner.
Thank you, Sir Alan. Expert witness fees. There's been a lot of complaint about the reduction in fees and the effect that's having, especially in London, on the availability of witnesses. Some NHS trusts saying that the fees are now beneath the costs of providing consultants to the court. Is this a problem that you're finding? Is it anecdotal or is it right?
Well, we have anecdotally also heard about fee cuts in London, but I can confirm that the LSE has made no fee cuts in London. I've also been told that there are no significant problems with access to appropriately publicly funded expert witnesses in London. Different types of witness have different rates, and the rates vary across the country, so maybe that's what people are looking at. But we don't actually see there being a problem in terms of people accessing experts in London.
And if more expert witnesses are to come from panels supplied by the NHS, but the NHS is saying now the rates are beneath those which are affordable for lead consultants, is this not going to make it difficult to draw expert witnesses from the NHS?
Well, I understand that staff employed by NHS trusts who undertake expert witnesses work generally, do so independently and are instructed and paid directly. So we don't see it as a problem.
They seem very high in any case.
Well, in terms of taking things forward, of course, this is being looked at as part of the legal aid review, and that does propose an immediate cut of 10% across the board, and also a further review as to how expert reports are costed generally. So this is a work in progress.
Thank you very much, sir.
Evans.
Do you intend to implement the scheme for the media access to the family courts containing the Children, Schools and Families Act?
Shall I take that?
Yeah.
This is part 2 of the Act from last year, which was a bill which I sat on and went through in the wash-up, and part 2 around transparency in the courts was never debated. And so we have decided not to implement it, at least until we've had the final report from Norgrove to consider. I have to say, I think it was a piece of legislation in haste which managed remarkably to unite just about everybody in opposition to it, from the judiciary, who thought it could be too intrusive, to the children's charities who thought it would compromise the welfare of and confidentiality of children, to the editors of newspapers who felt it didn't go far enough and was a fudge. And I remember having all of them in front of our Bill committee giving evidence united from completely different angles on why this was a wholly unsatisfactory fudge. It was always going to have to be returned to, so it was legislation which was put through in haste. And I think we need better transparency in the courts. I think everybody agrees that, because whether or not it's true, there is a perception that there is a bias in the courts. Various fathers groups will tell you it's a bias in favour of the resident parent, usually the mother. There are others who will tell you that there are incompetent or perhaps even malign social workers and other local authority people who have got it in for certain families and will therefore use whatever methods to extract a child from his or her family, and all that is brushed under the carpet, or that the judges are complicit in trying to conceal where justice isn't really being done. Now, some of all of that, in a little dose, may well happen. The bigger issue is the perception that it does by all sorts of different people. And unless we go back and address this properly, then I think we will always have this problem. It's a high-profile issue, particularly around adoption cases at the moment, which I've been dealing with. And so I'm very concerned with it. So this isn't something that we just put on the back burner and forget about. It is going to have to be addressed at some stage. I doubt whether it will be a straightforward implementation of the legislation that went through in that bill, but we will take a view and assess it again properly once Norgrove has reported in full.
Do you think people have confidence in the family courts at the moment?
I think some people do, some people don't. And those people who don't tend to be rather more vociferous and carry more weight in the media than those people who do, which is part of the problem.
Because I was reading the paperwork, and it seems the Family Justice Review panel were very impressed by the Australian model. Now, is there any intention of making any studies of the way things are done in Australia?
That they were impressed by it?
Yes, in particular they said that report commented panel members who travelled to Australia were impressed by the way in which members of the public and those waiting for their own cases to be heard could sit at the back of the court while other proceedings were in progress. They said the advantage in terms of parties, particularly people who represent themselves, being able to see how their own cases would be handled.
I think
there's also in Australia the press not permitted to report anything that identifies parties.
Interestingly, we had conversations with the Norgrove panel on this case, and they came back to us from Australia rather less impressed with transparency in the courts than what you've just read out suggests, which I was surprised about. So, and they will claim that the greater move to transparency in Australia, the way it has been done, has in some cases compromised the welfare of children. So I think it's a rather more complex matter than that. We will make sure there's a rather clearer explanation of exactly what they found in the... we will request that David Norgrove and his team do that in the fuller report. But I think this is going to be a separate piece of work that we'll then have to take on from the full report. You know, there's the Australian example, there's the Italian example, there's certain states in the US examples, all of which have got mixed reviews as to how better they've done. I am an inveterate believer in greater transparency in the courts. I'm also a believer in the concept of shared parenting should be enshrined in law. We put amendments to the 2006 Act to that effect. That's all part of the same issue.
But isn't the real tension in all of this is protecting children from adverse publicity?
Yeah.
How we manage that? Is that the main nub of the question?
Yeah, I think the most powerful piece of evidence when we were considering the 2010 Act came from Dr. Julia Brophy from Oxford University, who'd been commissioned by the then Children's Commissioner to make a study of the impact on children by greater transparency in the courts, along the lines of what was being suggested in that bill. And there was quite a comprehensive response from those children that they were very much against it, that they will be very much more reluctant to come forward and give their views and their statements to the court, because often in very sensitive situations, be it a family breakup or safeguarding, whatever it is, the last thing they wanted in any way is to feel that their personal circumstances were going to get into the public domain, regardless of all the anonymity qualifications that would go with it. Now that's quite a categorical piece of work that was done, and I think absolutely essential that we need to make sure that children are, or however the representatives of children are chosen, are comfortable that what they're doing doesn't undermine them. Otherwise, they're not actually going to open up on what they really think, and getting to the nub of the wishings and feelings of the children is absolutely key to all of this, and that must rank above satisfying greater press interest in exposing some of these cases.
Thank you.
Mr. Turner.
Thank you, Sir Alan. I wonder whether I could ask you about legal aid and litigants in person.
Yeah.
And I suppose pin you down on the timetable for the proposed reforms of legal aid. What are the? What is the proposed timetable for the reforms?
Well, the government is currently assessing the responses to the consultation. We look to come back with our response in the very near future.
Do we have a date for that, Minister?
We don't have a date for that at the moment. But to give you an overall idea, we're looking to introduce the legislation before the summer recess.
Right. I wonder whether the government has considered delaying changes to family legal aid until the Family Justice Review has finalised its report. Is that a consideration?
The Family Justice Review, from a legal aid point of view, is a separate and independent programme of work, and we don't feel that one should delay the other. I mean, as we've discussed in many different respects today, there are ongoing streams of work from the MOJ, from DFE, indeed from the judiciary, on all different areas, and I think the important thing is that we all coordinate and work together. So the Family Justice Review team has had representatives from both our departments serving on it. We have met with the review team. There's regular contact between the judiciary and the MOJ. There are contacts on all different levels that we know what's going on, so that there are no surprises in terms of who's doing what. I think that's the key.
I think I'm right in saying that family legal aid is going to be suffering a hit of something like £180 million out of the 350 million overall. Now, it must be accepted, I think it is even by yourself, that litigants in person will increase as a result. Yeah. And I wonder what protections could be in place to protect litigants in person cross-examining those that they accuse of very, very serious allegations of such as child abuse.
Yeah. Well, first, in terms of the numbers of litigants in person, we do think that there will be an increase in the numbers of litigants in person. But that given that we think that the overall numbers going to court will reduce, we don't see the additional pressures on the court being significant. So I think that's the first point.
Could I just press you on that answer?
Yeah.
It would seem to me that you are just thinking. Is there any evidence of what you've just said?
There's actually, we have conducted a literature review of the available evidence on litigants in person. And we also, of course, have our own internal management statistics, because there are a significant number of litigants in person within the system as currently exists. And the answer is not conclusive, to be frank. However, I've given you the position that we currently see it as. But what I would say is that whether or not there's going to be a significant or insignificant number of increase in litigants in person, the important thing is that we create a system that is more friendly for litigants in person. And I repeat that there are a lot of litigants in person in the system at the moment. A very important step in that direction was taken only... When did the family procedure rules came out? They came, 6th of April, the new family procedure rules came into effect. These have been worked on for a long time. They pull together all of the family legislation into one coherent set of rules. They will simplify those rules. They will simplify the application procedures. They significantly simplify the terminology involved within the system. All of these will greatly go to help litigants in person. We also have a stream of work within the MOJ to look to enhance the guidance provided for litigants in person, and also to make better use of technology. Particularly, we're looking for an online walk-through system to be created, so that people will be introduced to the system in a IT through the use of IT. So there's one point about whether we're going to have more litigants in person or not. There's quite another issue of saying we do want a better deal for litigants in person.
The increase in litigants in person coincides with the cuts to local government funding and an increase in what I think will be an increase in public law cases. Now, how will the government monitor the effect of more litigants in person?
Well, public law cases will receive legal aid. So, but I mean, there are concerns about litigants in person, and I think you voiced them at the start of your first question, that they could be there in court questioning the person on the other side. I have to say that's a concern now. It happens now, probably every day of the week, and the judiciary have pretty well honed tactics for dealing with that. If it's insisting that questions are asked through a third person, or indeed the judge being very particular on the sorts of questions that can be asked in the first place. So, it is an important issue, and it's an issue we have to deal with.
So if the system breaks down, what will the department do to step in? And how, I suppose, will you know that the system's breaking down?
Sorry, how do you mean?
If the system breaks down, what will the department do to step in, or will you not bother? Will you just let it happen? How will the government deal with...
break down?
Well, because we have an increase in litigants in person. I think there's bound to be delays as a result of that in court time. What mechanisms are in place? What's the plan?
We don't necessarily see there being an increase in time taken for cases in all types of case because of an increase in litigants in person. The evidence actually shows that in some types of case, having litigants in person on both sides may reduce the time taken in court. So we can't take these things for granted. The other big question is to what extent our proposals are going to lead to behavioural changes, and in particular non-court alternatives. That is, to what extent more people are going to want to go to, for instance, mediation or conciliation as a result of our proposals. So, but to whatever extent there is an increase in litigants in person, we don't see it leading to the system breaking down.
Just to add to that, that we did promise in the legal aid reform consultation paper that we would be doing a post-implementation review specifically to look at the impact of litigants in person. And we will be doing that. So it will be a question of looking at the backlog, looking at the actual length of cases taken involving litigants in person, seeing whether there's a connection. But as the Minister said, the evidence so far is not clear-cut on the subject.
I'm not sure that I've explained myself particularly well. Perhaps I've not. But I wonder how the government will be able to look at the system as it exists now, perhaps, and then compare the system as it will become once there's been an increase in litigants in person, and whether it's better or worse. That's, I suppose, my final question.
Well, our intention is not to have the existing system continue. What we're aiming at is to change the system, so that people realise that where they don't need to go to court, they shouldn't go to court and clog up the system. And our reforms are aimed at inducing that. And it looks as though, from the interim report of the Family Justice Review, that they think we're heading in the right direction in that regard.
Thank you, Minister.
Mr. Stewart.
I think we'd all agree that the implementation of the public law outline initiative has been a good idea from the very beginning. But it has been described in terms of actual implementation by our specialist advisor, Professor Judith Masson, as being patchy at best. What discussions have you ministers, both ministers, had with other colleagues at, for example, the Department for Communities and Local Government about the working of the PLO?
Well, firstly, thanks for bringing up the point about the public law outline, because it is an important plank of making the system work in a more streamlined process. Yeah. And the other point that I think we should put on record is that it has, I believe, recently been reviewed and updated as of April of this year, April 2010, from its original inception in 2008. So again, this is not a stuck-in-stone process. It's one that's being updated and reviewed. But I don't disagree with your point that, it is patchy. This has been spotted by the Family Justice Review team and is an issue that they are going to be working on further, and we will be looking to work with them on that up until the end of the review.
Could I add a further question then? What do you consider will be the effect of the inevitable departmental cuts, in other words, cuts to your own departments and also the local government department? What will be the inevitable effect of these cuts on the operation of the public law outline?
Well, we hope none whatsoever, and indeed that's the position taken by the Family Justice Review in its interim report. That each case should have a timetable for proceedings which is based on the timetable for the child, that judicial continuity should be kept in play. These are not things that should necessarily increase costs. In fact, if we get it right, they should reduce costs by avoiding duplication in the system.
Well, with respect, I don't follow that, because one of the problems we've already identified during this session is that sometimes social workers' reports can be patchy in terms of quality and in terms of time it takes to deliver. Yeah. And secondly, we also know that there are good and bad within CAFCAS. So frankly, if there are to be cuts in those two fields alone, then it will impact upon delivery of a proper service, will it not?
Well, let me take social workers, because at the moment a lot of money is being wasted on failure and a lot of money is being wasted on bureaucracy. And when a social worker is spending a very substantial part of his or her time complying with a very bloated rule book and filling in forms and ticking boxes on a computer, that is not the best use of his or her time, and more of that time should be spent literally eyeballing the vulnerable children and families that social worker is there to represent. That is not happening at the moment. And the whole point of the Monroe Review is to allow social workers to get on with the job of being social workers again, because too many of them have turned into computer operatives. too many of them have become, because of the system, the very best intentions of what has happened post-Climbier and the Laming report 11 years ago now, that the bureaucracy is driving what they are doing and risk aversion is driving what they're doing, and it's standing in the way of them making well-informed value judgments about the right level of intervention or not, which should be brought about to a particular family. Now, if we get it right with Munro, and it is a very important report that she has almost finished, and I will look to institute as much of it as quickly as possible, then we will have social workers doing more of the job of social workers much more efficiently, hopefully making more of the right decisions, and hopefully keeping more families together where possible, hopefully making the right call on what level of intervention is required where intervention is required, and making better informed judgments and submissions to the court process. Now, if we get all of that right, that is going to save an awful lot of money. One way it's going to save a lot of money is actually stimulating social workers to want to stay in child protection social work, so that we won't have the 20% vacancy level that we have in many London boroughs at the moment, for example, requiring us to expend a great deal of extra money on agency workers, which is expensive and also undermines the continuity that the families they deal with actually need as well. If we can get all of that right, there is a considerable saving to be made financially, but more importantly, a much better and enhanced service for the experiences of the children that we need to do a better job for.
Yes, and one of the points coming up very strongly from the review is that after CAFCAS has had its all its say, then sometimes these cases go to court and the judges do it all again, and that there's huge duplication as a result. And also that they say that too much time is often spent trying to predict the child's future welfare needs through the examination of the detail of the care plan, and that sometimes too much detail is given on things for the future, and that it would be better to look carefully at what's going on at that point in time and the immediate future, and then perhaps come back and look at things again at a future date when circumstances would probably have changed.
Thank you.
Thank you, Mr. Djanogly, Mr. Louhgton, Ms. Lee. Thank you very much for your help this morning.
Thank you.
Order.